Welcome to LawCats Live and our discussion of the recent U.S. Supreme Court decision, McGirt versus Oklahoma. And I want to start by recognizing that the University of Arizona sits on the original homelands of the Tohono people. This recognition is especially important given the topic of this case. In a treaty with the U.S. government in 1832, the Creek Nation agreed to give up their ancestral lands east of the Mississippi River in exchange for land in what would eventually become the state of Oklahoma. That land was to be, quote, a permanent home to the whole Creek Nation. The question before the U.S. Supreme Court in McGirt was whether, after many broken promises, intervening laws and actions, whether that reservation still existed. Let me start by introducing myself. My name is Tessa Dysart. I'm a clinical professor of law and the assistant director of legal writing. But most importantly, I think for this case, that I'm a member of the Muscogee Creek Nation. My maternal grandmother and great-grandmother were born on land that had been part of the Creek Nation in Oklahoma. According to family records, our ancestral lands were in Georgia, and our family moved voluntarily from Georgia in 1827 and 1830. My maternal grandfather was also Native American, he was Cherokee, but his family never registered. Given my history, I've been following this case closely. There's actually been 2 cases in front of the court in the last 2 terms discussing this very issue. So I was excited to see the court's opinion, and I'm extra excited to be here to moderate our discussion. Quick housekeeping notes. I will be ending us at 1. That's when the webinar ends. Please use the Q&A feature for Zoom webinars to ask questions. I have a few questions that were pre-submitted, and then I'll moderate the questions that we receive on Q&A. So if I look this way, it's at my other monitor. All right, let me start by introducing now our panelists. First, we will hear from Professor Rebecca Tsosie. Professor Tsosie is a Regents Professor at the James E. Rogers College of Law, and she serves as a special advisor to the Provost for Diversity and Inclusion. She is of Yaqui descent and is a faculty member for the Indigenous Peoples Law and Policy Program at the university. She's widely known for her work in the fields of federal Indian law and Indigenous peoples' human rights. Then we'll hear from Professor Melissa Tatum. Professor Tatum specializes in tribal jurisdiction and tribal courts. She's written extensively on these topics, including being a contributor to the 2005 edition of Cohen's Handbook of Federal Indian Law, which the court talked about frequently in its decision. She is was the co-editor of an 8-volume set containing opinions issued by the courts of the Muscogee Creek Nation from 1832 to 2006. And she joined our faculty from the University of Tulsa, so she has experience on the ground in Oklahoma. And then finally, we'll hear from Professor Barbara Atwood. Professor Atwood is the Mary Ann Ritchie Professor of Law Emerita and co-director of the Family and Juvenile Law Certificate Program at the University of College of Law. She is, of course, a real wildcat, a graduate of our law school, and her scholarship explores topics at the intersection of civil procedure and family law, with a particular focus on issues of voice and representation for marginalized groups. She has served as a judge pro tem for the Tohono Nation since 2013, and she's an expert on ICWA, the Indian Child Welfare Act, and she'll talk about some of the ICWA implications in this case. So now let me turn it over to Professor Tsosie.
Thank you so much, Professor Dysart. Thank you for that beautiful opening and welcome, and it's very significant to me to have you as part of the panel. I realize that you are serving in a role as moderator today, but you are so powerfully embedded in the jurisprudence, both Indian law, constitutional law, and your family history. So I'm just very honored to be here, and I appreciate my distinguished colleagues. I know we're going to have an exciting discussion because they are luminaries in our field. So my job on the panel is to give you the rough outlines of the case, its reasoning, and its significance, and to try to do that in 5 minutes. And I sense that my federal Indian law students may be out there laughing because I can't do anything in 5 minutes, but I'm going to do my very best to hit the high points. And first of all, I want to say thank you to all of the audience members for being part of this. The case that we are going to talk about today, McGirt, is being described by scholars and attorneys of federal Indian law as a game changer. And every major meeting for Indian law practitioners, whether they're in natural resources, cultural resources, ICWA, other dimensions, they've all got a topic saying, what are the implications of McGirt for our group? So why is it a game changer? Well, first of all, it makes the past and what might be viewed as the distant past by some people in the United States present. And it does so in a very real way, saying that those treaty guaranteed lands that comprise the Creek Nations reservation still exist, are still intact today. And therefore, we ought to give jurisdictional consideration in this case, which is a criminal case, to the federal government's authority to prosecute the tribal member for the crime rather than the state government. Now, why is that so significant? Because for many years, as I think Professor Tatum will talk about, the mantra in Indian law was that there were no reservations in Oklahoma, with the possible exception of Osage for various reasons, which Professor Tatum can get into. But that was the mantra when I was in law school, and everybody uncritically accepted it. And I'll never forget going to a conference in the 1990s, and our wonderful, wonderful colleague who's passed on now, but those of you who know him and love him will still remember him, and I can hear his voice, Professor G. William Rice, who was at Tulsa. And he said, that is fiction, that's mythology. The reservations were never disestablished, they still exist. And he and his partner, the late Browning Pipestem, another wonderful Native scholar, basically said they had done the research, the reservations were intact. So number two, this case is described as a victory for tribal sovereignty and treaty rights. And yet the tribe is not a party to the case. The case arises through these very horrendous circumstances where a criminal defendant commits sexual assault against a 4-year-old child, and his identity as an enrolled member as a Seminole, and the crime being a felony, executed in state court, and he gets 1,000 years plus life in prison for that heinous crime. Does he have a defense? His defense is the state had no jurisdiction over him. That, if anything, should be a felony offense prosecuted by the United States under the Major Crimes Act. This is how jurisdiction in Indian country works. So if you're a Native defendant and you commit your felony offense in Indian country, regardless of the identity of the victim, you can be prosecuted and probably will be prosecuted by the federal government under the Major Crimes Act, 18 U.S.C. 1153. The jurisdiction for that statute is that the crime took place in Indian country. What is Indian country? 3 categories: Indian reservation, an allotment still held in Indian title, even if there isn't a reservation, or a dependent Indian community, and we'll put that prong aside. So in Oklahoma, if the mantra was no reservations, were there Indian allotments still held in Indian title? Yes, and that issue had been litigated. The federal government had jurisdiction over a crime similar to this on those allotments. But because the mantra was there wasn't an Indian reservation, and this crime had happened on fee land, not an allotment held in Indian title, the state of Oklahoma assumed that it had jurisdiction. So this case came into the Supreme Court, number one, because the earlier case that Professor Dysart referred to, the Murphy case, had gone all the way up to the Supreme Court on a 10th Circuit, finding that the Creek Nation reservation was intact. But Justice Gorsuch had to recuse himself, and it was a 4-4. So McGirt gets the Murphy question into the Supreme Court, but through the path of the state court. So that is significant. Okay, so what ends up happening here is the issue about whether or not the reservation had been created, number one, and then whether or not it had been disestablished by Congress. So did Congress create it? Because that's all that you can have is Congress creates a reservation, and only Congress can disestablish or diminish what it has created. And the history of that, Professor Dysart went through in broad strokes, is very important. The Creek Nation was removed out of its treaty guaranteed lands, and I think there were 3.5 million acres of those treaty guaranteed lands in the Southeast, removed to the Indian Territory, and an 1856 treaty with the United States government grants them that reservation in perpetuity. Moreover, it is in fee simple absolute, the best title you can have, and they specifically say this reservation shall never be part of any territory or state, and the Creek Nation shall always be self-governing under its own sovereign authority on its territory. Now that sounds like a pretty big promise to me. What happened? Civil War. Then there was another treaty, 1866, in which the Creek Nation paid reparations to the United States because it had sided with the Confederate Army, and it gave them half of its treaty guaranteed reservation in that eastern part of the land. So all we're talking about is the remaining part of that, which the United States government secured forever and in perpetuity to the Creek Nation. So Gorsuch's opinion is very important, and many people say, did it change the standard for deciding these issues? And the answer to that is no. The standard was always present in the Supreme Court's jurisprudence in Solon v. Bartlett. Only Congress can disestablish a reservation once it is validly created, and this one was. And Congress must evidence clear intent to do so. How do we look at that? Statutory construction. Express language in a subsequent statute to diminish or disestablish. That's what you're looking for. There was nothing in the subsequent actions in this case. The mere fact that the reservation was allotted in 1901 is not sufficient to disestablish or diminish a reservation. That was fee land, and the Creek Nation agreed to distribute to tribal members, but there was nothing where Congress took that reservation away from them. So really the argument here in Oklahoma, it was that statehood, 1907, the state assumed that it has jurisdiction over that reservation and acted accordingly. And those allotment cases that I spoke of, those were later challenges to validate federal law on those Indian allotments. But the reservation issue wasn't litigated. So the standard still remains. There were two other prongs in Solon v. Bartlett that said, well, sometimes you can look to contemporaneous events to see if the statutory language is ambiguous. So Congress in one section says it's diminished, Congress in another section says it's not diminished. What do? Well, you go to the events and you see what actually happened and how people behaved and what the legislative history said and all of that. And there was this prong of Solon v. Bartlett that looked at population demographics today and the amount of ownership that was tribal versus non-tribal. That de facto diminishment prong would have threatened to swallow the entire test. But in a 2016 case authored by Justice Thomas, Nebraska v. Parker, he said, no, once the reservation is established, you see whether Congress did anything to terminate it, and you don't use those population demographics or tribal presence in the area to determine that as of today's demographics. So the legal test has not changed. Justice Roberts would like to say that it did change, that we can be more encompassing about historical events over 100 years in the legal conclusion, was the reservation disestablished, but it was not disestablished. So that is the big issue here. They kept to the test. Gorsuch kept to that, and he has some wonderful quotes in there. But the second issue is, are there limitations built into the holding? And he was very careful. Justice Gorsuch was very careful to say, this is restricted to an interpretation of 18 U.S.C. 1151A, the reservation prong, in light of the Creek Nation's reservation and only for purposes of Major Crimes Act jurisdiction under Section 1153. He did say there are these arguments about civil regulatory jurisdiction and the slippery slope and the parade of horribles and all this other stuff. But he said, you know, civil cases, they're equitable defenses in those cases. That's a different world. I'm not going to get into that today. And I know that we're going to get into that in Q&A. So the very bottom line of his opinion is, if Congress has not withdrawn the reservation, it is not up to the court to do so judicially, the appropriate balance of power here. And he holds the government to its word. It made a promise, it needs to keep the promise. Okay, I'm very delighted to hand things over to Professor Tatum, who can tell us more about the dissent. There are 4 vehement dissents here in the case, and tell us a little bit about Oklahoma in general. So honored to be here with you today, Professor Tatum.
Thank you, Professor Tsosie, and thank you to my fellow panelists and to Professor Dysart for moderating, and to the law school for having this panel and this webinar. As Professor Tsosie said, pretty much everyone in Indian law thinks this case is a game changer. And I want to talk about 3 specific ways that it's a game changer. The first one is, it's shocking that we can even do something a game changer when the court says the law is the law is the law and we're not changing it. So it's a game changer that in Indian law we expected to follow the law. And it's shocking to us that the court did. Because in so many cases since 1978, the Supreme Court has not followed its own tests and has changed the test to disadvantage tribes, particularly when the rights of non-Indians were involved and the ability of the tribal to exercise jurisdiction over non-Indians. It's also a game changer for people outside of Indian law. I've actually been teaching the Murphy case for over 10 years as part of a CLE I give occasionally called Enough Indian Law to Avoid Malpractice. Because I teach the Murphy case as a case for failing of law schools and a failing of legal education. Murphy was for all the horrific nature of the McGirt case, Murphy was a capital murder trial. Murphy was sentenced to death for his crime. And he said, the state doesn't have jurisdiction over me to even pursue this. But that wasn't even raised till after his direct criminal appeals were over. His attorney at trial didn't raise it. His attorney on appeal didn't raise it. It wasn't raised till collateral proceedings. It is shocking that the state spent money on a capital murder trial when it didn't even have the power to file the charges, and that nobody questioned it for almost 10 years before it got to the system and got raised. And that's shocking because so many people think of Indian law as this niche field that doesn't apply to anybody unless you're involved in it because it's just too technical and too specialized. Yet in Florida versus Seminole Tribe, the court changed the interpretation of the 11th Amendment that it then extended out into everyone else. In Ling and in Appointment Division versus Smith, the court changed the First Amendment test in cases affecting only Indians and then applied it to everybody. But yet no one watches Indian law. And here we have a case that says, this is the test that's always been, we've always articulated, we're gonna stick to it. And it means the state has no criminal jurisdiction over a lot of people that it's been trying and convicting and sentencing to death. And then the third way that this is a game changer is that one of the things, as Professor Tsosie mentioned, is there was this parade of horribles, right, that kept being raised. That's why, because of the changing demographics, because Oklahoma has done this for 100 years, we just need to let it be. So we have this tension between keeping the law the way it is, but yet condoning a test that violates that law. And all the parties that were in favor of changing the test and upholding Oklahoma's jurisdiction kept arguing, if you do this, all these people are going to be let out of jail. The tribe's going to exercise all this jurisdiction over all these people that are going to find out they live in Indian country when they thought they lived in Oklahoma. And it's just going to be a mess. But Oklahoma, people in Oklahoma have lived with that mess for a long time. Tribes exist in Oklahoma. There are almost 40 tribes in Oklahoma. And as Professor Tsosie mentioned, there's been this mantra that there's no Indian country, there's no reservations in Oklahoma, but there is Indian country in Oklahoma. But yet the papers forget that. But yet you drive around the state and there are all these signs entering the Sac and Fox Nation, entering the Cherokee Reservation. So there are all these signs posting that you're entering and leaving Indian country, but nobody thinks about it in terms of jurisdiction. But yet the tribes in the state of Oklahoma have had to deal with this for a long time because the Supreme Court has vague tests for jurisdiction. The tests are very clear for jurisdiction, but they're not so clear for civil jurisdiction. Tribes in the states negotiate agreements. They've got a series of compacts dealing with cigarette taxes, dealing with gaming issues. There's cooperative agreements between cities and counties and tribes about criminal jurisdiction, cross-deputization of law enforcement officers, because as a practical matter, life has to go on in the face of legal uncertainty. So a lot of people, when Murphy case was not resolved by the Supreme Court the first time, and it was rolled over to the next term, when the court accepted McGirt instead, because it clearly couldn't get an opinion of Murphy. That told us the state of Oklahoma needed to do something different. So it kept trotting out these parade of horribles. And as Professor Tsosie said, Gorsuch said, that's not our problem. We have the law. And the law says this reservation, as this territory has not been disestablished. This is Indian country. And so we have to uphold that. So now the question is going to be, what impact does this opinion have on the and how to deal with this? In the short term, to change some things, and in the long term, change some things. But Oklahoma and the counties and the attorneys in Oklahoma said, don't change the law just because of practical problems. We've been dealing with this forever, and we've got ways around them. One of the things that is probably going to change is Indian Child Welfare Act stuff. And so I'm going to turn it over to Professor Atwood at this point.
Thank you. And I'm also really honored to be a part of this panel. I admire all three of you enormously. So this is a real pleasure. Yeah, the state of Oklahoma argued in its brief that that this was going to have terrible consequences, and in particular in the child welfare realm. Under the Indian Child Welfare Act, I think that's my phone ringing, folks. I can't turn it off right now, in case you hear it. Under the Indian Child Welfare Act, as many of you know, there is an emphasis on where things occur, where children are living. And under the act, which was enacted in response to a destructive history of federal government and state governments in separating Indian children from their families. Incidentally, that separation of children from their families has a certain resonance today, but it finally attracted attention back in the 1960s and 70s and prompted Congress to enact this statute, which has now been on the books for over 45 years, but is still very much a subject of controversy. One of the most important provisions of this act was to reaffirm tribal jurisdiction over child welfare matters concerning tribal member children. And that in particular was to recognize, to reaffirm, not really to grant, but to reaffirm tribal exclusive authority over Indian children as defined in the act who reside or are domiciled on a reservation. And that means state courts have no authority over these matters, child welfare placements and adoptions involving Indian children residing or domiciled on a reservation. When I heard about McGirt and when I read the decision, I thought immediately, whoa, this might have implications. There's all of a sudden a much broader territorial jurisdiction for the Muscogee Creek tribe. And does this mean that placements that had been entered by state courts of Oklahoma, which would amount to hundreds, if not thousands, of placements regarding Muscogee Creek children, would they be subject to disruption? And in looking at the briefs in the case, that's exactly what Oklahoma argued, and others who were opposing the recognition of these treaty-based borders for the reservation. They said, gee, we're gonna end up having this, a bunch of these adoptions, placements are gonna be void because the state courts have done them, and the courts of the tribe would have the only right to go forward. And the tribe had a really good response to that. Actually, there's a very robust history of tribal state cooperative agreements between the Muscogee tribe and other tribes in the state of Oklahoma, partly because of, I think, this somewhat tortured history trying to figure out who's got jurisdiction when. And the tribe said, we don't want to upset these placements. We think going forward, we certainly can enter into agreements that will preserve the stability and finality of these existing decrees. They said, we're the last people who will want to upset them. On the other hand, I think that going forward, there will be a difference in the sense that the tribe now has what you might call jurisdictional leverage in these cases. It's, whether it is prepared at this point in its tribal court system and its child welfare system to handle a big increase in cases is something that's of practical concern. Tribes can always decline jurisdiction, but it will be participating in these agreements from a position of power, I believe, because of this core provision on jurisdiction under the Indian Child Welfare Act. And so it's interesting in the briefs, Oklahoma talked about the Indian Child Welfare Act as if this provision is going to upset and it's going to expand the power of tribal courts to the detriment of the population. And that's a common, I think, view of tribal courts based on mistrust, that they believe that tribal courts will be biased against non-members and in favor of members. And that, in fact, empirically has shown to be false. Indeed, in the first case ever to reach the U.S. Supreme Court involving the Indian Child Welfare Act, the court held that an adoption decree had been entered without authority by the Mississippi state courts and basically said your recourse is to go to the Choctaw Tribal Court. That Choctaw Tribal Court actually reaffirmed the adoption decree, the adoption by a non-Indian couple, because of the court's understanding of the sensitivity of those family relations of the children, the Choctaw children who had been adopted. But that to the extent that there's fear about what tribal courts might do that's based on this sense of unfairness, I hope people who are watching this don't share that fear, because tribal courts are, there are many tribal courts of great sophistication and dedication throughout the country. Who are doing a fabulous job in administering justice within Indian country. So bottom line is that the state of Oklahoma used family law as one of its parade of horribles, that this is going to expand the jurisdiction of the tribe and also upset existing decrees. I think the upsetting of the existing decrees is not going to happen. There's going to be cooperation in terms of its expanding the tribal court. That may be, that doesn't trouble me in the least.
Great, thank you. That's actually a really interesting point about the tribal courts, because that's something that I've heard expressed, this fear that they won't be fair. And one person said, oh, they're elected. And it's like, well, many state court judges are elected too. And so, fairness in the judiciary is a topic that goes beyond just tribal courts. Well, we have a lot of questions. I'm very excited. So let's start with, and I'm going to try to combine some of the questions that we have together, but I'd like to start with this one. What impact do you think this decision will have on tribal jurisdiction outside of Oklahoma? So despite any limitations Justice Gorsuch might have written into the opinion, what will be the practical impact?
I think one of the issues is that everyone has to remember that the McGirt case was not a jurisdiction case. The law being decided was not jurisdiction. The law at issue, the question at issue was, is this Indian country? So it was a decision about how to decide the boundaries of a reservation. the boundaries of the territory, the geographic territory, under the control of the tribe. Many tribes have already had their boundaries settled by earlier cases, and where there are still, for McGirt to affect it, the question is going to have to be, has this reservation been disestablished or diminished? And that test is the test it's always been. So unless there are questions about the boundaries of the tribes, the physical geographic boundaries, McGirt's going to have no impact.
What about Professor Tsosie, did you want to add something?
I just want to say that I think that part of what people worry about anytime that there's a strong case in support of what are viewed as ancient treaty rights, then the faction that isn't promoting recognition of tribal sovereignty or treaty rights will go to Congress and say, look, could you clear this up? Because there are a lot of reservations that were kind of, really, some of them could have been diminished or disestablished, and we actually need you to do something to weigh in and cure this problem. And so Indian law is famous for that being the unfolding political environment. So otherwise, I agree with what was said.
What impact will this have on non-Indians who live in these lands? And will there be any impact, I'm going to kind of combine questions here, on the standards the court uses in determining whether the defendant is native or non-native?
Tessa, I could just offer a family law response to that. Under the Indian Child Welfare Act, often Indian children have parents that are, one is a tribal member and the other is not, is non-Indian. And the jurisdictional provisions of the Act are triggered by the status of the child and the place where the child resides. So it in fact can affect, to the extent that we now have an expanded, the understanding of the jurisdiction has been expanded territorially. That means there will be more families that are going to be affected, and those families may involve non-Indians. I want to just add one other thing. It's not just the Indian Child Welfare Act that is going to be, that may be impacted by this decision. When you have interparental, your garden variety interparental custody disputes between potentially an Indian parent and a non-Indian parent and a child residing on a reservation, there's a uniform jurisdictional act that essentially all states have enacted that governs who gets to litigate, what court gets to entertain litigation on these disputes. That will also be impacted by this decision. It also is something that can be resolved by cooperative agreements between states and tribes.
There are fairly well-established definitions about what being an Indian means in civil cases and in criminal cases. And I don't think this is going to affect those definitions. But I think as Professor Atwood said, as we said repeatedly, this affects the boundaries, the geographic territory. So it's going to affect the territory over which the tribe can exercise jurisdiction. And there are some questions in civil jurisdiction. The tests in criminal jurisdiction are pretty established and pretty clear. The tests in civil jurisdiction are vague and are uncertain in various points. And those, there may be some issues and some push now. We haven't had any clarification since Nevada versus Hicks about what the actual test is going to be in civil jurisdiction for a tribe's ability to exercise civil jurisdiction over non-members of the tribe. The case has been up a couple of times before the court, first in the Plains Commerce Bank case and second in the Dollar General case, and the court has not resolved some of the ambiguities. So there might be some push to resolve those ambiguities.
So now talking about the court and further Indian law cases, some people were surprised by Justice Gorsuch's opinion here. So is this a product of him being a Western judge, the first Coloradan since Byron White? So is it a product of having someone who understands Indian territory? Is it a product of his own view of textualism and statutory interpretation? He has a recently published book that extensively discusses his views on statutory interpretation. What can we make of this mystery of Justice Gorsuch?
Who wants to step in on that one? I think we probably all have an opinion.
I'll go first just briefly. There were at least two big cases that he authored this term. Bostock, the Title VII case that interpreted discrimination on the basis of sex to include discrimination on the basis of sexual orientation and transgender status. He wrote the majority opinion there, and some of his language is very, very similar to the language in this case, where he says, look, we're just interpreting the text. We aren't going to be persuaded. We can't be persuaded by predictions of dire consequences. That would be inappropriate for the judicial role. He says judicial humility requires us to stick to the written text. And here it's essentially saying we look for words that we don't find those words from Congress. Therefore, we're faced with the decision we're reaching today, consequences to one side. So it's very, he is developing, I think, a textualism that ties in with the judicial sort of restraint and of course he's got lots of people on the other side who are saying he's doing exactly the opposite.
I think it takes all of the above, because I think it's not just his knowledge of Indian law. He comes from the 10th Circuit, right? The 8th, 9th, and 10th Circuits are the most active circuits in terms of Indian law cases. So he had some familiarity with Indian law before he went to the court. To my knowledge, he was the first justice to hire a native law clerk, to hire a native judicial clerk. But also Justice Scalia, who was one of the most ardent textualists, who was fond of sticking to the old interpretations, wrote in a case, in Indian law, an old case is old law. So just because you're a textualist doesn't mean that you're going to stick to the test. A lot of, I think, what happened, my guess, I have not studied his record, I've not studied his history, but my guess is that his exposure to Indian law led him to realize that these tests are very well grounded in history. They mean something, they have an impact, they exist for a reason, and to abandon them just because of modern views of what should happen is incorrect. And by modern views, I don't just mean modern versus old-fashioned. I mean, there's a tendency from the Supreme Court since 1978 to abandon legal principles for judicial preference about certain ways things should be viewed as fair. And those are viewed as fair outside the context of history that is so important to understanding Indian law.
Okay. Professor Tessa, did you want to add anything on Professor Gorsuch, or?
Oh, if you've got a lot of questions, please continue.
Okay.
I know we're running out of time, so.
Okay. So this question, I'm trying to figure out the best way to phrase this. So if McGirt creates a problem that needs a solution, that's an if. What is the solution? Is the solution Congress? Is the solution an MOU with Oklahoma? Where do we go from here?
So that is the Indian law quandary right now. That is the million-dollar question. And what I want to say about this opinion is Justice Gorsuch issued a principled opinion based on the law, based on a construction of the history, and leading to a specific outcome, in this case particularized to these facts. He says to glom that onto whatever has been happening for 100 years and just give credence to that would be to give effect to stories rather than statutes. And take that into our field. We are a field that has these competing strands of jurisprudence because people do give effect to stories rather than statutes, and the Supreme Court hasn't always stayed in its lane, given the prevailing view that Congress has plenary power. Now, what does that mean that Congress has plenary power? Does that mean that every time a dominant portion of your society has a problem with tribal sovereignty, that you should go running to Congress asking them to limit or tribal sovereignty? And I believe that the opinion tells us no. Indian law is a matter of law. It's not a matter of political vagaries. And to that principled jurisprudence means that you have other mechanisms to effectuate tribal sovereignty and self-determination. Those sovereign to sovereign agreements that the state and the tribes have negotiated over years have given a political framework in Oklahoma. But now, as Professor Atwood says, there's leverage because we know that that is a reservation. So we can't negate that. So I believe that we should continue that strand of self-determination.
Professor Tatum, do you have a view
I would absolutely
on?
agree with. I would absolutely agree with that. I mean, this is not a national problem. The intricacies of how to handle the details are not a problem in Oklahoma because of the history of Oklahoma and the different status of the various tribes there. Oklahoma and the counties in Oklahoma and the tribes are in the best position to work out the solution.
Yeah, absolutely. I agree on that, absolutely. So building on that question then, you know, how much can we say that this opinion, you know, even though as you both mentioned, it's not a new test, it's applying the same old test, but how much is this opinion really focused on the unique situation of the Muscogee Creek people or the unique situation of Oklahoma as compared to other tribes in other states?
I think the issue goes back to the 2016 decision that Professor Tsosie mentioned, which was Nebraska versus Parker. So obviously it came out of the state of Nebraska. And there the court said the test is the same test we've been using. That third part of the test, the demographic can't overcome the first two. So I think the McGirt is specific to Oklahoma in that the test is to look at the specific history of the statutes of that tribe. But the general legal test is the same and applies the same everywhere. Right? Hagan versus Utah versus Bartlett, they came from states, but the test is to remain consistent. So it's a hybrid, it's a consistent test, but to apply the test, you have to look to the specific factors and historical elements to that tribe.
But I'll just jump in. I think that it is specific to Oklahoma, but it is also, I think, a really strong mandate to courts to interpret carefully, to not too readily jump to a conclusion of that a reservation has been disestablished. It gives strength, in other words, to that position and to not shy away from it just because you think there may be unknown consequences to it. So it's a powerful command, and we've seen it in a smattering of cases already around the country where people are saying, well, we're going to go back and look carefully at this now to see if maybe this reservation wasn't disestablished in areas other than Oklahoma. It also, I mean, we haven't really talked about it, but because the Murphy case involved a death penalty, I think a lot of people were paying attention to the recent the execution of the Navajo man with the opposition of the Navajo Nation and many other groups. In many circumstances now, with McGirt, if there is a capital crime committed on the reservation by the native man governed by the Major Crimes Act, capital punishment won't be available under federal law. And so that's that's going to have tremendous consequences, and Murphy is an example of that.
One other thing I would add that I forgot to add earlier is it also is going to reinvigorate treaty arguments, right? Since 1978, when the Supreme Court started detaching Indian law from history and from foundational principles to the field, the court had started homogenizing Indian law across the country. And so Indian law became this one homogenous bundle of provisions that applied to all tribes. But 2 terms ago in Cougar Den, right, we had a case based on the interpretation of the treaty signed with that tribe. And here we have an interpretation that goes back to the Treaty of the Muscogee Creek Nation. So I think there's the lesson here for everybody, that you don't just stop at Indian law principles. You have to go back to the treaties and see if there are treaty arguments in a particular case.
Yeah, that really resonated with me as I was reading the decision. There's many times that the court requires a clear statement from Congress to do something significant. And so it seems not unusual in constitutional law to do that in this particular situation. So we're at 1 o'clock. We have a few more questions, and our panelists have agreed to stick around for just a little bit longer, but not too much longer, because I think several of us have 1:30 meetings. So, so I have a few more questions here, and I am willing to take a few more questions in the Q&A as well, if you have them. One question that's very interesting, something actually my husband and I have talked a bit about, is the economic impact of this decision for the Creek Nation and indigenous peoples in the United States. Do you believe that there will be an economic impact on the Creek Nation with this decision? Any of our panelists? Maybe Melissa, since you're sort of more familiar with on the ground stuff in Oklahoma?
I think it's inevitable that there's going to be some economic impact, but I'm not sure what that's going to be or what it's going to consist of. I think it's something that the tribe and the state are going to have to face, because clearly more things are going to fall within jurisdiction, which means their court has to be able to handle it, which means money spent. But also, if they can regulate, if the regulations spread wider, they may need to increase their administrative infrastructure and their agency infrastructure. A lot just depends on the negotiations that they enter into with the counties that surround them and the state of Oklahoma, and how that responsibility gets allocated.
Well, and in particular, there are oil and gas operations, natural resources being extracted from lands that now are within the reservation. That's going to have an economic impact.
Yeah, it was actually funny as I was looking at some of my family history. My maternal great-grandmother had an allotment that she sold to send my great-grandfather to barber school. You know, this is family stories are kind of fun, but it was unclear if he had sold the mineral rights, and so there was, you know, these stories that were passed down of discussing, you know, that impact. And yeah, there's definitely in Oklahoma, you have mineral rights are an important important part of the land. So we touched on this a little bit ago, but with respect to other tribes that have been party to cases holding disestablishment, do you think there'll be a chance now to come back and look at those cases more carefully?
Professor Tsosie, do you want to take that?
It's fact specific. So if anything, the implications are for the other reservations of the 5 civilized quote unquote tribes. So the Cherokee and Choctaw, Chickasaw, they had a similar situation. And so all of those reservations are arguably still intact. And so the Oklahoma situation is going to be different. The diminishment cases in the Western lands they're based on a different history and set of facts. So again, there may be an increased focus on whether or not we should find, you know, a liberal standard or you know, based on Solon v. Bartlett and those other 2 factors. I mean, some people are really steamed about that. Some people think if the population demographic looks a certain way, you should, you know, hold the case based on that, but that's not what the law says. So again, I would just restrict it to its facts, but to say that the situation for those other reservations is very similar, and so it obviously is going to have huge implications for Oklahoma.
Going back to the point of looking to treaties, do you all anticipate McGirt impacting the revitalization of the canons of construction arguments more generally? You know, perhaps the question is more about Gorsuch and whether Gorsuch will continue this newfound support for tribal sovereignty in other ways, which we kind of talked about a little bit. But what do you see the canons of construction's argument doing for these, based on this decision?
I don't see that he said that this is about tribal sovereignty. I don't think he said that. I think he said this is about justice and the federal government keeping its word once it makes it, unless it specifically says that we're changing the circumstances. And the net effect of that is he also acknowledges that the Creek Nation survived the policies of the federal government, the Curtis Act, seeking to shut down its government. That was an act of injustice. They survived that. And so he certainly says they at least deserve what they bargained for and what was never validly taken away from law. And that is the epitome of justice. And a beautiful essay that Joy Harjo, who's Creek and the nation's poet laureate, she said, you know, old people always said that justice was going to prevail. They always knew that there would come that day. And she said, all you have to do is walk out there. She said, the Creek language, the Creek culture, the Creek people are everywhere. That is the Creek Nation. So he got that.
And for people who haven't read the opinion that are on the webinar right now, I really urge you to read it, to read the majority opinion, because even though it's very true, as Professor Tsosie was saying, it is about law and it's a commitment to law. It is also a story. It tells the story of these transgressions, and it is a commitment to the government keeping its word. And I think that's an important sort of theme. I can't imagine that Justice Gorsuch won't keep that theme alive in his jurisprudence going forward.
I do find it very troubling that the justices in dissent were not willing to do that.
I know.
I think the fact that they were willing to ignore the history in those bills is very troubling.
Yeah, I was surprised with the dissent not really addressing sort of the clear statement requirement. I don't think that the dissent did a good job of addressing that issue in the opinion. I think this is a great.
They couldn't do it and have their side prevail. They just decided that 3 years ago in Nebraska versus Parker.
That's true. Well, I think this is a great place to end on, and this notion of justice and justice prevailing. As I was reading the opinion, it struck me that this 1832 treaty was a treaty done when Andrew Jackson, who fought the Creek Wars, was president. And I think it highlights so many injustices done, not just to the Creek Nation, but so many other tribes across the country. So it's a great day for tribal victories, and I think it's an interesting new era at the court, and we'll see if some of the questions of civil jurisdiction are taken up by the court in the upcoming terms, and perhaps there'll be needs for lots more new federal Indian law case books to reflect all these new decisions. So thank you so much to our panelists. It's just fun to be part of this discussion, and thank you to our participants for sticking with us. And we hope you'll join us on future LawCat Lives. I think we're doing these once a month, and there'll be great opportunities to learn something new each month. So have a great rest of your day.
Thank you.
Thank you.